He had been inside for 14 years. In 2 days, the gate would open and he would walk out with $40, a bus ticket, and a set of civilian clothes that had been sitting in a storage room since the last time he had gained weight without meaning to. He had a plan, a sister in Columbus with a couch, a phone number for a landscaping company that was hiring. He had counted down from 14 years to 2 days and he was almost there. That morning, he asked to see the warden. Calvin Merritt arrived at Crestwood Correctional in the spring of 2014, convicted of armed robbery. He had held up a pharmacy in Cincinnati with a gun he had borrowed and returned the same night. No one was physically hurt. He was 29 years old, broke in the specific way that stops feeling temporary and starts feeling structural, and he had made a decision in 4 minutes that cost him 16 years. With good behavior, he had earned 2 off. Inside, he caused no problems. He worked the kitchen for 6 years, then transferred to the library. He earned 2 vocational certifications. He was not liked or disliked by the corrections officers in any particular way. He occupied the specific category of long-term prisoner who has made a private arrangement with his situation. Not peaceful, not bitter. Just present. What almost no one at Crestwood knew was that Calvin Merritt had been thinking about the same thing every single day for the past 14 years. In October 2012, 2 years before his arrest, and 4 years before Crestwood, Calvin had been outside a bar in Dayton, Ohio, at 11:30 on a rainy Thursday night when a man named Terry Holt approached him from behind with a knife and demanded his phone and his jacket. What happened next took 4 seconds. A struggle, a fall, a concrete curb at the wrong angle. Calvin did not intend to kill anyone. The paramedics who arrived 20 minutes later agreed, in their clinical language, that intention had very little to do with the outcome. Calvin ran. He ran until he was far enough away to think clearly, and what he thought was, "There is no version of going back that does not cost me everything." 3 weeks after Terry Holt died on that Dayton sidewalk, a man named Darnell Oates was arrested for his murder. Calvin followed the case from a distance. He watched the news, told himself he was monitoring it, told himself he would know if something went wrong. There was an eyewitness, a woman who had been across the street and gave a description that matched Darnell Oates. A man with a prior conviction and the misfortune of resembling the person a frightened woman had glimpsed from 40 feet away in the rain. There was a public defender managing a caseload no single attorney could handle well. There was a jury that deliberated for 6 hours. Calvin was in his Cincinnati apartment when the verdict notification appeared on his phone. He sat on the edge of his bed and read it. He closed the app and opened it again. He sat there for a long time. He told himself Darnell would appeal. He told himself the evidence was too thin to survive scrutiny. He told himself the system, for all its demonstrated failures, had correcting mechanisms, and that those mechanisms would eventually function. He told himself these things with the insistence of a man who requires them to be true. He was still telling himself some version of them when he robbed the pharmacy in Cincinnati 2 years later and his own life bent sharply off its axis. Inside Crestwood, he found the law library. He began following Darnell's appellate case the way some men follow sports, compulsively, tracking every motion and ruling through the long procedural road of a capital appeal. He learned to read court documents. He understood the sequence: direct appeal to the state Supreme Court, post-conviction relief petition, federal habeas corpus. The careful architecture of exhaustion a condemned man must climb before the courts will consider the merits of his case. He read every opinion as it came down. The first appeal had argued ineffective assistance of counsel. Calvin read the state's response brief until he had it memorized. The public defender had made errors, had failed to hire an expert who might have challenged the eyewitness identification methodology, had not subpoenaed surveillance footage from 2 businesses on the block. But the errors had not met the legal threshold of prejudice required to reverse a conviction. No reversible error. The court denied it. The second appeal challenged the eyewitness identification directly. This was the one Calvin had particularly hoped for. He had read everything he could find on eyewitness reliability research, on cross-racial identification rates, on the specific lighting conditions of a rainy October street at 11:30 at night. He had been almost certain this appeal would succeed. The court denied it. The science was compelling, it wrote, but insufficient to overturn a jury verdict absent corroborating evidence of unreliability. What Calvin could never fully set aside, what came to him in the specific clarity of 4 in the morning, was a single exchange from the trial transcript he had eventually obtained. The eyewitness, on cross-examination, had been asked to describe the lighting at the corner where she saw the altercation. She said, "It was raining. It was dark, but I know what I saw." The defense attorney had not followed up. Calvin had read that exchange perhaps 300 times over the years. He knew what she had seen from 40 feet away in the dark and the rain. He also knew what had actually happened. He thought about writing a letter. He thought about it for years. In the quiet hours of the overnight kitchen shift, when the work was mechanical and his mind was free, he composed it, careful, precise reconstructions of that Thursday night in Dayton, every detail that would establish his presence and Darnell's absence. He thought about who to send it to. He thought about what would happen when it arrived. He thought about the moment his words entered the record and became permanent, and every time he reached that point, he stopped. Not because the words were not in him, because the consequences were not abstract, because 14 years of counting down had made what was waiting at the end of the count feel very real and very close. In the fall of his 13th year inside, a man in his housing unit left a newspaper folded open on the common room table. Calvin picked it up out of habit. He picked up every newspaper he encountered. The article was 6 paragraphs, buried in the regional section. The Ohio Supreme Court had denied Darnell Oates' final appeal. An execution date had been set, 11 weeks away. Calvin put the paper back on the table. He walked to his bunk. He could not say, later, exactly what changed in the weeks that followed. He had spent 14 years maintaining a partition in his mind. On one side, the legal question of whether his confession would make a practical difference. On the other, the plain fact of what he had done and what it had cost another man. He had lived almost entirely on the legal side of that partition. The procedural question was manageable. It could be analyzed, deferred, turned over and refined indefinitely. The plain fact was not manageable. He had kept it behind the partition for 14 years. As the weeks counted down, the partition stopped holding. He stopped going to the library in the evenings. He ate less. He lay awake in the early mornings and thought about Dayton and the rain and the 4 seconds and the sound of a man hitting concrete. He thought about Darnell Oates in a cell somewhere in southern Ohio, having exhausted every road the law offered. He thought about his sister in Columbus, who had been visiting every other month for 6 years and talking about the future as though it were already taking shape. He was 2 weeks from his release date when the execution was 4 days away. He sat with that equation for a long time. In 4 days, Darnell would be dead. In 2 days, Calvin would be free. He thought about the couch in Columbus, the landscaping contact, the door that opened from the inside, the ordinary unremarkable texture of a life he had been away from for 14 years. He thought about what it would mean to have all of it, knowing he had been 48 hours away from preventing the worst thing and had chosen not to. He did not sleep that night. He asked for the meeting at 6:30 in the morning. He was shown into the warden's office at 8. He sat down in the chair across from a man he had spoken to perhaps 4 times in 14 years, and he said, "I need to tell you something about the murder of Terry Holt in Dayton, Ohio, on the night of October 14, 2012. He spoke for 22 minutes. He described the bar and the rain. He described the knife and the struggle and what came after. He described driving back to Cincinnati and watching the news for days. He described the verdict alert on his phone and the years of appellate filings he had followed from a library 30 feet from his cell. He named the street corner. He named the bar. He gave the exact time. He described what he was wearing and what Terry Holt was wearing and how the confrontation had started and what he had done immediately after." The warden listened without speaking. When Calvin finished, there was a silence. Then the warden picked up his phone. What followed was not clean or fast. An execution date does not pause easily. There were calls to the prosecutor's office, then to the attorney general, then to a judge. Documents were pulled and compared. There was an hour when nothing seemed to be moving, and then there was another hour when everything was moving at once. An emergency stay application was filed in the Franklin County Courts at 12:41 that afternoon. The stay was granted at 4:17 p.m., 17 hours and 43 minutes before the scheduled execution. Calvin Merritt did not walk out 2 days later. He was transferred to a holding unit pending formal charges. He was ultimately indicted on the original murder, with his own 22-minute confession as the state's central piece of evidence. He pleaded guilty. He received a sentence of 25 years to life. Darnell Oates walked out of Chillicothe Correctional on a Thursday morning in March. He was 51 years old. He had spent 9 years on death row for a murder he did not commit. His mother was there. A few reporters were there. He said very little to them. Calvin Merritt is currently incarcerated at a facility in southern Ohio. He is 54 years old. Under his current sentence, he will be eligible for parole no sooner than 2042. There was a brief period after the stay was granted when people called what Calvin had done courageous. He gave one interview through his attorney before sentencing. He was asked whether he believed he had done the right thing. He said, "I did the necessary thing." He said he wasn't certain those were the same. Darnell Oates has not spoken publicly about Calvin Merritt. In the one interview he gave after his release, he was asked what he wanted now. He said he wanted to grow something. His brother in Akron had a yard with space for a garden. He said he had spent 9 years trying to find a way to understand what had been done to him, and he had stopped expecting to find one that made sense of it. He said some things don't resolve. You learn to live around the place they left. The reporter asked if he had any message for the man who had finally come forward. Darnell was quiet for a moment. Then he said, "I don't have anything for him." The reporter waited. Darnell let the silence hold. After a while, the interview moved on. Story notes. Fictional narrative. All names, locations, and institutions are invented. The story explores a moral situation plausible within the American criminal justice system.